Good morning. I am Lynn Gitelis. I'm from the Golden Valley League, and we'd like to welcome you to the program, The Invisibility of Rulemaking. The forum is being sponsored by the West Metro Alliance, which includes the local leagues of Brooklyn Park, Osseo Maple Grove, Crystal, New Hope, East Plymouth, Golden Valley, Minnetonka, Eden Prairie, Hopkins, St. Louis Park, South Tonka, and Wayzata, Plymouth. League of Women Voters is an educational organization organized at the local, state, and national levels, and our goal is to encourage citizens to participate in government. If you are not a member of the League and are interested in becoming a member, please be sure to leave your contact information on the sign-up sheets at the back. And please also note that both men and women are encouraged to join us. We do study and take stands on issues, but we do not endorse or support political parties or candidates. We encourage all members and people who are not members to become involved in your community and the party of your choice if you have one, or the non-party if you would prefer that. I'd like to remind you we are a nonpartisan political organization and the views of the speaker are his own. We do not assume responsibility for the contents of any speaker's statements. We would like to take about 30 seconds at this point. Would you please silence your phones? Either turn them off or silence them or whatever you need to do, because we'd like to be respectful of our speaker. As we mentioned, today's program is about rulemaking and administrative law. Some people have pointed out that they don't really know what that means. Administrative law is an area of rulemaking and lawmaking that is pretty visible to those of us who spend time with the business of getting bills passed, but it's fairly invisible to a lot of people who may have interest in an issue, but they don't understand what the role of the agencies and rulemaking is. So what we're going to cover today, what our speaker is going to cover, is what is rulemaking, what is the process, can citizens engage in the process, and are there additional resources if you're interested in learning more about it after today. Our speaker today is Judge Eric Lipman of the Office of Administrative Hearings. Prior to his appointment to the bench in 2006, he held a number of posts in state government, including his work as Senior Policy Advisor to Governor Pawlenty, a State Representative from Washington County, the Deputy Secretary of State of Minnesota. He received his JD from George Washington University Law Center in Washington, D.C. A key part of Judge Lipman's role at OAH is to undertake the legal review of proposed rules. In his forum, Judge Lipman is planning to provide an overview of the rulemaking process, explain why Minnesota makes new rules this way, and detail for us how ordinary citizens can make contributions to this process. Just as a personal aside, when he's not on the bench, Judge Lipman divides his time equally between his children's sporting events, volunteering with a local women's shelter, and adding to his collection of Israeli pop music. So if you need any recommendations on music, there you go. Judge Lipman, please.
Thank you so much. I'm so very grateful not only to the League and its Metro Alliance for hosting this important session this morning, but also to the City of St. Louis Park, who has generously allowed us to meet in the council chambers, and likewise to Park TV, who is taking this presentation to a still wider audience throughout the metropolitan area. So grateful to the League and to the City and to Park TV, and particularly to all of you who braved a cold winter morning this morning to join us. But I'm hoping to make it worth your while. I'm certainly going to try to do that. This is what the League was hoping to accomplish this morning. A couple of things: what every Minnesota voter should know, how the state rulemaking process works, and I'm going to try to argue today that it's an important part of self-government. May well be invisible now. I'm hoping in an hour from now it won't be so invisible and will inspire you enough to take an active role in it, because again, my key premise here is this is a key piece of self-government, government by, for, and of the people. Okay? So how it works, how you, as citizens, your neighbors, your Christmas card list, your Cub Scout troop, your community group, your JC group can best engage in the rulemaking process. And we're very, very eager for everybody who has things of substance to contribute to the decision-making process to take a role. Okay? There will always be people in our society who want to reserve the decisions to themselves. I think the premise of the rulemaking process is that we believe in the wisdom of the group. We would much rather have distributed and transparent decision making, and the way we do that is by active folks like you receiving the kind of training that they need so that they can understand and process and engage in that process to share their best thinking, to share their critical analysis, to share their best judgments, to contribute to the wisdom of the group. And we're also eager to give you the tools by which you can make your presentations the most effective and most thoughtful and most substantive. We're going to try to give you some materials today that will be the working tools for genuine citizen engagement and making a substantive difference in the kinds of rules that come out of executive branch agencies, rules that have the force and effect of law. So this is really very serious. Okay? And likewise, it's important because this is how self-government works. If you're involved in the decision-making and crafting of the laws that we all live under, we certainly believe that the substantive results of that will be much, much better than if you weren't in the room and participating. Okay? So these are the key assumptions, and this is what we're going to try to accomplish today. Lynn began talking about what is a rule. Let me just read briefly before I go on, and we'll come back to this idea in sharper detail in a second. But the statutory definition, what it says in Chapter 14, the definition of a rule, is every statement, every agency statement of general applicability and future effect. So it's a rule because it is generally applicable to more than one party or one case, and it's prospective. It has future effect. This will be how we'll decide that question in the future. A statement of general applicability, a rule, we're going to be using this to decide something in the future, and we're going to do this generally. Okay? And it includes amendments, suspensions, repeals of rules adopted to implement and to make specific the law enforced or administered by that agency or to govern its organization or procedure. So the things that agencies do, okay, to the extent that they are generally applicable to more than one party and they are of future effect, is a rule. Okay? That is a very large category of things. If you think about the things that organize or are implemented by a state agency in the executive branch. Okay? That is a very wide swath. Okay? So just so that you know the general topic of what we're talking about, these kinds of rules, and then we'll show you about the process about why we do the things that we do and how we do the things that we do. Let me take a step back first with a compliment. Jefferson wrote to his friend William Jarvis in 1820, "Self-government is not at all possible unless the citizens are sufficiently educated to enable them to exercise oversight." So thank you because Jefferson worried in 1820. If we think them not enlightened enough, and he genuinely worried, were people going to show up for the hard work of self-government? And we're concerned that they're not enlightened enough to exercise their control with wholesome discretion. The remedy is not to take it from them, but to inform their discretion by education. So again, we have two paths. There will always be people, as I suggested before, who's glad to play the role of dictator or commissar or expert or technocrat. But that's not what Jefferson hoped for us. Jefferson hoped for an enlightened citizenry, broadly distributed power, transparency, active citizen engagement. Is it hard? You bet it is hard. The next 40 minutes will be hard. But it is totally, totally worth it, considering the alternative, which is, again, some expert, some small group, some one person make that decision for you. We believe in the wisdom of the group, okay? And so that's why we're eager that you're training, and we hope that when you get trained up, you'll train someone else so that they can engage, because this is what Jefferson hoped for, the informed discretion, okay? A little bit earlier, he made another important writing, which is important for today. Okay, you'll recognize it. "We hold these truths to be self-evident, that all men are created equal," and I would add women, and particularly in the League of Women Voters, created equal, and most importantly, they're endowed by their Creator with unalienable rights, and that to secure those rights which have been given by God, governments are instituted amongst men deriving their just powers from the consent of the governed. A radical, radical idea when first written down. Because up until that time, King George III thought the line went from God to him, and if there was things left over, well, that was by his grace. A genuinely revolutionary idea that the delegation didn't go from God to the king, but God to who? Who's in that second box? Voters, yes. Women voters and men voters. I've got both. Okay, so a very different set of delegations Jefferson is talking about. God to the voters, and then voters to whom? The legislature. So like Representative Lipman or Representative Thompson. And as both of their examples prove, it's a temporary lending. Representative Lipman, Representative Thompson aren't permanent commissars. They're not life peers. They don't stand there and make decisions forever. It's a temporary lending of power, okay, that is always inherent in the people, okay? It's inalienable. Once given, it can't ever be permanently defeased from the voters. It comes from God to the voters and stays with the voters. Important concept. What we're going to be talking about is the next set of arrows. From the legislature to whom? Agencies, executive branch agencies. Okay? So again, think about this kind of line. And again, it's from God to us in whole, a temporary lending to the legislature, and then there are further strings, as we'll see, as we go from the legislature to executive branch agencies. Okay? So, just using my laser pointer, God to us, no strings, complete. And in fact, it's inalienable, it stays with us forever. From us to the legislature, based on 2-year terms, you have to work within the Constitution, you have to follow certain procedures on presentment, you have to have majority votes. All of those are strings on the lawmaking power. And then, as we'll find out, there are still further strings in Chapter 14 of our state statutes here in Minnesota that go to when executive branch agencies actually enact laws. And we'll explain how. Okay? They're not legislators, but they do things which have the force and effect of law. Let's talk about the 2 office spaces here. What can we say about office space A? What are some features of it? Elected. What else? Pardon me?
Formal.
Formal. Very formal. What else?
Public record.
On the public record, yes. What can we say about the, this room? What are some features of that room? They're all in together. What else? I'm focusing up here. Do you know what that is? It's Park TV. Look at that. Transparent, not transparent? Okay. And anybody knows what's above here, above the television cameras? The gallery. Okay, so even if you're not on television, you can come down and watch. Anybody know who these people are? Well, no, I mean, but are these people well known?
No.
Do you know your state representative?
Yes.
Okay, and if you don't, they've got what on the front of the desk? Their names. Okay, so high transparency. On television, you get to select who goes there in an open, formal process. You've got nameplates on the desk. They do things in open forums. Their actions are recorded. Okay, so we know a lot about that. How about the folks who are doing rule writing in Office Space Bay? Probably none of the above. Transparent? Maybe. Did we elect that person? Didn't elect that person. So even when the delegation goes into an agency at a commissioner, that person's not on the ballot. You didn't vote for the Commissioner of Human Services, or as bright and as capable as she is. We probably would have, but but we didn't. The folks down in the agency below didn't stand on any ballot. Don't necessarily work in open in the same way that we do. Certainly the proceedings are not televised when they draft rules. So very different lawmaking process, and we would be concerned, I think, right, about generating laws in this office, right? Why would we be concerned? Not transparent, okay? So there's some dangers there. So wisely, this room puts strings on the exercise of lawmaking powers by this room. Let me talk about some of those strings. And this is the slide that I'm going to spend most of my time on today, okay? A key piece is the public notice process, number one. And with that, whether there are or when there are new delegations of authority, a new statute, the legislature says, we'd like you to promulgate rules that have the force and effect of law in this subject, X agency or X board, okay? When there are new delegations of authority, within 60 days of the effective date of that new delegation, the agency is obliged to go and ask you, well, what do you think about this subject? What should we do? Okay, they have to notify members of the public that they're going to be undertaking rulemaking in this area, and they have to go out for public notice. That public notice is important. Among them, they have a running list of people who would like to be notified of actions in that area on rulemaking, and it's a set of lists that I would encourage folks, if you have a particular issue area or agency that you're interested in or area that you're following, that you write to them and say, I'd like to be on your list. Very convenient. You can either receive them in U.S. mail or by electronic mail. Okay, so these notices. We're thinking about doing rules in the transportation area relating to road striping. And if you're a road geek, and there are, you would get notice in advance if there's a new delegation of authority or if they're using an old delegation and thinking about rulemaking in that area. Okay? And indeed, some of the larger agencies will allow you to drill down by topic and enroll in rulemaking lists, not only things for the entire agency, but the specific area that you're in. And the Minnesota Pollution Control Agency is among those. I think the Department of Health is, and certainly the Department of Labor and Industry have things where you can choose the subject matter, so you're not getting notices in all of the things that the agency does, but just in the areas that that relate to you. And so those lists are very helpful. And again, so if you're interested in particular topics, I would encourage you to write in to the agency and say that you would like to be on their regular rulemaking list for the topics that interest you. Secondly, even beyond their list, the legislature makes them go out and search for, quote, persons who may be significantly affected by the rule. So even if their lists are not that detailed, there are 20 or 40 or 80 people on the list, they need to think about the rule from the perspective of the stakeholders and go out and actually affirmatively find people who might well be impacted by the rule and include notice to them and their associations. And so in the elections context, even if the League of Women Voters didn't sign up to get rulemaking notices from the Secretary of State's office, the Secretary of State's office would send them to the League because they're a group that's likely to be substantially affected. And so the agency is under a statutory obligation to find people who might be interested and drop them a note and say, we're thinking about rulemaking in this area. That's another important piece, and subject to an independent review by me. When we review these rules for sufficiency, we try to see, have they been transparent in their process by notifying not only the people that enrolled to receive them, but also lots of other folks who may well be interested in this topic, notwithstanding the fact that they didn't actually enroll in the list. The SONAR is the Statement of Need and Reasonableness. This is a statutory required memorandum, an assessment document of the proposed rules, and requires the agency to do a detailed memo about the features of its rule and the impacts of its proposals. Okay? Among the things that the legislature requires in the SONAR, I've just abbreviated it, but it's the Statement of Need and Reasonableness, is who is affected by the rule, the costs of implementation of the rule, are there less intrusive methods of getting at the same goal rather than doing it this way, the alternatives that the agency considered and rejected, the compliance costs of the rules, the costs of doing nothing at all. If we don't promulgate this rule, what will happen? Comparison with federal rules, if any, on the same subject, and the overall impact of adding this rule to the regulations we already have. Okay? So again, a detailed multi-factor analysis, really looking at all of the various sides and features of that particular rule. And it's in a public memo that they need to circulate and make available. And so just as I tell my 11-year-old who quarrels with me about doing his math homework, I desperately want him to show his work. Why? Why do I ask my 11-year-old about showing his work? Well, not only did he do it, but what else? That he understands it, and what else? Accountability, how so?
That he has to prove he's done the task.
Okay, that's certainly a piece of it. I want to make sure he's done all the steps. Why else is it helpful when I'm looking over his homework? If he made a mistake, and my 11-year-old, regrettably, makes a mistake every now and then in his math homework. In this process, the sonar helps citizens, particularly when we're relying upon the wisdom of the group, to detect mistakes. Legal errors, procedural errors, just damn fool ideas. It's going to come out in the memo, I think. Or if there's some reason to doubt, if the memo is incomplete, that will be a source of comment too. Hey, you missed a step or 10 in the calculation here. And here's a better way of doing it, okay? So inform public comment by, is this needed and is it reasonable? It's going to come out in the memo, in the writing, and that's why that is an important piece. We don't just take the agency's word for it. They are required for every piece of the rule to make an affirmative presentation of facts. The agency cannot say, we chose this rule, well, because we said so. Or, seems okay to us. That's not an affirmative presentation of facts, okay? So they actually have to have some support to show the reasonableness. Again, the R in sonar is not only needed, but reasonable. And it's reasonable if they, in fact, have facts to support that choice as opposed to others. Doesn't have to be the best choice. Doesn't have to be the choice that Judge Lipman would make. But they have to have some rational basis, some affirmative presentation. We have some facts that underlie and support this choice. I mean, that is a key hedge against arbitrary government. We don't have government, why? Because we said so. That's not a sufficient answer. It's because we've made a reasonable choice, and here are our facts, which are verifiable or not. Okay? There are strict time limits for promulgating the rules, particularly with newer delegations. They have to be within 18 months of the effective date. Okay, they have to start and get to a notice to adopt. So if the legislature says, we want you to do something, you calculate 18 months from the effective date of the statute, and if they haven't gone and developed a proposal and issued what they are going to do, they lose the authority to do that rulemaking and have to go back to the committee and say, will you renew us because we didn't complete our work on time. An important accountability measure, at least from the legislature's point of view. Okay? When we tell you to do something, we want you to start somewhat seasonably to undertake that work. Here's where I come in. We're doing an independent legal review to make sure that they followed all of these complicated procedures, that they demonstrated an affirmative presentation of facts, and that they have authority for the rule, and that it's needed and reasonable. Again, we don't just take their word for it. We hire somebody else whose paycheck and working conditions and everything else isn't dependent upon the agency and say, what do you think? Okay. Traditionally, we've been finding about in 40% of the rulemakings that were presented, there were legal defects. I think that the agencies have improved their practice. In the last fiscal year, they've cut that rate in half. So people are learning. We're improving the process, and it is an iterative dialogue between our agency and the other executive branch folks who to do this. We do trainings like this for them, and so we are improving, I think, the overall results because there are fewer legal errors. Okay. Lastly, there's gubernatorial review and veto. So there is in a sense, a large political check if you think that the agencies are off the rails. I think it's, as a practical matter, it's more important when constitutional officers are promulgating rules. The only time that veto has ever been threatened, and the one time it was used, was when the governor and the secretary of state were of different parties. And you can imagine that they might well have different views on same-day voter registration, which was the occasion for both the threat and then the later the later actual implementation of that, something of interest to the League. Okay? And you can imagine that, you know, the secretary is independently elected of the governor and has a delegation that's separate from, and a mandate separate from the governor's. And so that is a political check on agency rulemaking. So just by way of quick recap, we closely review the assumptions. We don't take anything for granted. We closely review the sonar. We rely upon detailed comments from the public to animate where we should be looking at. Okay, we do an independent review, but it's helpful if people write in. Gee, Judge, I think there's some problems in this area. We'll talk a little bit more about that in some detail. We focus testimony at the public hearings on possible defects. And again, there's an independent review. Somebody who's apart from the agency, not in that chain of command, saying, yeah, this is good or not good. What's the whole theory? The legislature begins all of Chapter 14, our Administrative Procedures Act, with this idea. Chapter 14, the Administrative Procedures Act, is limited only to procedural rights. It doesn't guarantee anybody anything but a process, a way of making decisions. You don't have any substantive rights. I don't get rules of a particular nature or quality or outcome because of Chapter 14. All we get is a process. But, and here's the important but, we believe that there will be better substantive results in the everyday conduct of state government because of doing it this way. I'm a firm believer that that is in fact true. Is it complicated? Is it a hassle? Is it slightly more expensive? I think. But in the long run, I think we have better self-government because we do the things that we do. And because we don't take these assumptions for granted, there's a searching review, and there's wide, open, distributed decision-making. This yields to better substantive results. How can I prove it? My best way is comparing Courthouse A and Courthouse B. Anybody know what Courthouse A is? Any lawyers? It is the Supreme Court. Okay, this is our local courthouse. That's the Minnesota Judicial Center, just to the right of the Capitol as you're facing the Capitol Dome from, with Cedar Street on your right-hand side. Courthouse B, this is, okay, real trivia, administrative law geeks only. No, okay. This is the Prettyman Leventhal Courthouse in Washington, D.C. It is the home of the U.S. Court of Appeals for the District of Columbia Circuit. When you sue the federal government or a federal agency over what you think are arbitrary and capricious federal rules, if this were in the federal system, you would most likely go to that court. Okay? So, when I'm looking at who has sued because they're unhappy and they think that an agency has acted arbitrarily and capriciously, they've just promulgated rules that have no rational basis whatsoever. That's the legal standard. Okay? The agencies are allowed to do things that are reasonable, but not unreasonable. Okay? So there have been people who have been unhappy with the substance of a particular rule. They file a lawsuit and say, Court of Appeals, this rule is irrational and should not be allowed to be given effect. Since the turn of the century, since 2000, there have been 3 reported cases challenging the bona fides of a particular rule. Are we not litigious? No, I wouldn't suggest that that's the answer. But the process that we have of identifying and cleaning up and correcting legal defects, I would suggest to you, argue to you, takes many cases out of the system such that there's only been 3 since 2000, January 1, 2000. And, we're into the second decade here and good ways into it. So I think we're doing pretty well. If we would compare to the federal system how many lawsuits are, and I'm mindful and willing to concede that the federal government has a wider territorial swath, and they have other agencies and lots more pages of the Federal Register, but I'll get to that in a second. But the rate at which there are decisions and suits over arbitrary and capricious and claims of unreasonable rule is 3 a week. Okay? So very different rate. I took 1790 and divided it by 36. Let's just assume, I don't think it's true, but just to be generous, that Minnesota only has 1/50th of the share of the U.S. Court of Appeals for the District of Columbia Circuit's docket when it comes to claims of unreasonable rules. Even that would be 10 times our experience. If you divide it by 50, you get to 36. I would suggest that taking, even if you take this number, 90% of the litigation out of the system, and I think that's a very generous assumption, you've done some good work. Okay? I think this process, as difficult as it is, and as much as it requires as far as citizen engagement, actually leads to better substantive results, and, as importantly, public confidence in the rules. I might not like the decision that the commissioner came to, but it's not irrational. You cannot, or rarely can one, I think, of good faith, say that that the rules that have been adopted have no rational basis whatsoever. It's not the best choice, maybe not the choice that you would make if you were commissioner. Those are reasonable differences of opinion. But I think that the rate at which our government acts arbitrarily and capriciously and irrationally is lower because of what we do. And that's the argument I'm making to you. So how can we engage to be very effective? At a rulemaking hearing, there are three things, the big three. This is how I focus on it. The duty of the judge is to make a report on these things. The authority for the agency to promulgate the rule, whether they followed all of the procedures in Chapter 14, and there are lots of things that they need to do in order to have a proper rule, all of those strings, and they demonstrated a need and reasonableness for each of the portions of the rules. There's our affirmative presentation of facts, with an affirmative presentation of facts. We're not just taking their word for it. Authority, compliance with the procedures, have they shown need and reasonableness for each portions of the rules. Those are the three things that I'm focused on. Many times, and I think it's a difficult part of the process, people come to a public hearing and say, I would like the rule X, and I know that the commissioner might think it should be Y, but this is a better rule. Judge, I would like you to pick the better rule. The delegation of authority doesn't run from the legislature to me. They didn't say, Lipman, please pick the best rule that you think you're persuaded that you would like. No, I'm only there to make sure that the commissioner hasn't acted irrationally, or at least in this third part. And that's a different standard. I'm keeping them from arbitrariness. I'm not, I'm not the Commissioner of Human Services. I'm not the Commissioner of Public Safety. The delegation doesn't run to me. Okay? And also that they're coloring within the lines, that they have authority to do what they set out to do, and that they fulfilled all of the relevant procedure in order to get to that point. Okay? I'm not the Commissioner of Public Safety. I'm not the Commissioner of Human Services. I'm just making sure that they're following the law and that they're acting within their delegations. The testimony at public hearings that ALJs like the best actually have a theme, and it's not any different for those folks who haven't been to a rulemaking hearing than making a presentation to the local city council or the planning commission. But we like presentations where folks have a theme or objective in mind, that they highlight the key points, mindful that they can write in afterwards with more detailed comments. And following each public hearing, there is usually a very lengthy, somewhere between 5 and 20 calendar days, within which people who are at the public hearing and even people who are not at the public hearing can write in their comments. So very handy that people can just hit the key high points of their presentation, knowing that a neighbor and a fellow stakeholder is behind them in line. My practice is I like to go through the roster of folks who show up at a public hearing at least once with short remarks, and then I'll stay for successive rounds for whomever would like to stay. My record so far is 7 rounds of rulemaking comments, but we're delighted to say I'm always the last one to leave the room. Okay, so if you do come to a rulemaking hearing, it's very helpful if you have specific citations to the rule that you're concerned about. I'm concerned about the phrasing of this particular rule. That is more likely to get a searching review because you've given a detailed citation. We don't have to hunt around for exactly the point. Again, accompanied by more detailed comments. You can follow up if it wasn't Clarence Darrow-like presentation at the rulemaking hearing. You don't need to worry. You've got 20, in most cases, 20 calendar days to write in. And that you address the big 3 that I talked about. The authority of the agency to promulgate the rule, of their compliance with the procedures, and the need and reasonableness for each portions of the rule. Why? Because the judge's report is based upon those things. So you're actually engaging at the thing where the process is headed, and the process's own charter. boy, do we have resources for you. It may seem like that, but that's a helping hand that comes down with the materials on the back. And if you don't have them, be sure to get them one on the way out. I have a very handy handout called Internet Resources for Rulemaking in Minnesota. It looks like this. It has some internet links. Some key things in there are House research. The folks who do research for the Minnesota House of Representatives has 3 little 2-page pamphlets on rulemaking. They're very handy as far as an overview. Like those a lot. The Reviser has a listing of all the rules by executive branch agencies. If you're interested in the work of a particular agency and its current art, you can click on that link. The Reviser's office is also developing a very, very exciting system. Its acronym is MARS, is the Minnesota Rules Status System, in the same way that for those folks who are used to getting information about pending bills before the legislature, who have ever done a search into that website, they're doing the same kind of citation system for rulemaking. And so that you'd be able to follow and receive electronically, without having to go down to an agency and look through their files, all of the materials related to rulemaking, both going forward, on a going forward basis, and also historical information. If you've ever wondered, how do they get this rule? What was their thinking? What was their rationale? Those materials, they've gone through the History Center and in agency documents, and they're now putting those materials online so that they could be accessible by anyone with an internet connection wherever they are in the globe in their pajamas. And a really very exciting thing, and the Reviser is a hero for making those kinds of documents, again, about self-government, access to wherever there's an internet connection. The State Register, that's where folks announce new rulemakings. There is an informal group of agency rule writers. Some say it's a support group, a mutual support group of agency folks who do this work for executive branch agencies. They're called the Interagency Rules Committee. They have an annual seminar, free and open to the public, if you'd like to get training on that. And they also have a manual that shows every step of every procedure. Imagine the Joy of Cooking kind of cookbook for rulemaking. Is how the agency managers approach it. Now, it is a 400-page document, but everything that a rule writer would want to know, and every procedure is mapped out in measure 2 cups and then 3 ounces of butter and stir rapidly kind of directions and detail in these forms. And there's lots of useful handouts in that. Obviously, there's the statute and our rules. And then the last link is to OAH's own opinion archive. We do opinions when we do find defects. Those are posted to our website, and we have a fully searchable database so that if you're interested in how the judge makes decisions generally or in particular areas, you can search to your heart's delight on the internet through that link. And so everything that a citizen ninja who wants to engage in the process would need to know is just a mouse click away with these particular links. So, my quick recap is rulemaking is an effective part of state government. I think from the legislature's perspective, and speaking as a former member, the legislature makes delegations to executive branch agency because there are some gap-filling or technical questions which would bog the legislature up if it were to rule and make decision-making and gather public testimony or make detailed fact-finding on specific technical questions that, as long as they are cabined within tight authority and reviewed by an administrative law judge, the legislature feels safe to give a policy declaration and a delegation and say, resolve this question, and if we're unhappy, we can always repeal the rule or change the statute. The legislature is always superior in any of these kinds of things. There's not permanent just because of an executive branch agencies. They're, as their charter, are to see that the laws are faithfully executed, and the laws and the lawmaking power still resides with the legislature. But I think that from the legislature's perspective, they find it convenient for certain kinds of technical questions to say, we'll sculpt a broad policy, and we'll allow this public decision-making process to fill in some of the technical details and to make sure that we get it right, or that people who are affected will know about it and let us know if it isn't. Okay? When we undertake rulemaking, unlike, I think, some other possible choices, and indeed sometimes in the federal system, we rely upon the wisdom of the group. We're going to engage those people who enroll. We're going to search for the people who still might be impacted even though they don't enroll. We're going to have very low thresholds for prompting a hearing. Even in the cases where we don't have a hearing, we're still going to have an independent review by, I would suggest to you, a trained legal professional to make sure that they've gotten it right. Okay? And so we're open and transparent and eager to hear from everybody's best thinking. I think the legislature is naturally distrustful of government by technocrat, and so has created a system which is as public as public could be. Is that approach complicated? You bet. I mean, we sat for 40 minutes and I've gone through pieces of Chapter 14, and it is a dizzying array. But I would suggest to you that it leads, notwithstanding its complexity, that it yields much better substantive results, both in public confidence that we can believe that there is a rational basis for the policy decisions and technical decisions that are made by executive branch agencies, but also many times agencies change their mind because they have informed comment. The system assumes that there is not a monopoly on wisdom, okay? And the system in that respect is absolutely right. You bring about better results by your engagement. Okay? By sharing your personal experience, by what you know, what you've learned, and actively participating in the decision-making process, you make things better for the community around you. And with that, you have my thanks, and I think I have 10 minutes or so for questions before we get on to the panel.
If you have questions, come to the microphone. This is being recorded, this microphone over here. And in order to get your questions on the recording, we need to have you open your clubhouse.
And I'm going to do my best to repeat the question for the benefit of those folks who are tuning in by Park TV.
Are the commissioners are all appointed politically?
Yes.
And so they have an agenda because of the political appointment?
Well, I think that one can fairly assume that commissioners of executive branch agencies, because they're appointed by the governor and subject to confirmation by the Senate, are held accountable for their policy views. Those folks who have policy views that are far outside the mainstream don't tend to get confirmed or appointed, for that matter. And so I think that that's probably true. I think, though, if members of the public are concerned about a particular commissioner's policy agenda or where the agency is going, that is a fair comment for public comment, which is, we think that this has been, this policy decision, as expressed in this rule, has been impacted poorly by political considerations in ways that undermine its basic rationality, that it has become an irrational or arbitrary rule. That would be a really very helpful comment to make. Or it's pure politics and it hasn't been authorized by the legislature. Another colossally helpful comment to make, because again, these go to what I describe as the big three: the authority, the compliance with procedure, or the underlying need or reasonableness of those choices. So if politics have infected any of those, that gets to the heart of the legal review. Is that helpful?
And then the last question I have is that sometimes when I've read some things, it is written not in plain language. It is written at a whole higher level that I am not able to comprehend it. I'm just a regular Joe.
The legislature, the question is sometimes that we get to legalese. And so the legislature has in fact, or does in fact, feel your pain. I'm just looking for in the statute to do a short dramatic reading here on this point. Hold on just a second. So talking about notices to the public, the mailed notices, and this was an innovation that Representative Fran Bradley, formerly of Rochester, he's still of Rochester, but a former Representative Bradley, put into the statutes. The mailed notice must include either a copy of the proposed rule and an easily readable and understandable description of the nature and effect of the rule, and an announcement that a free copy of the rule is available. And so I think that many legislators who, as part of the process, were copied on the rulemaking notices turned to this and said, you know, I don't have a white wig like Judge Lipman. You know, I'm not of the House of Lords. You know, what is this thing that is coming across my desk? Representative Bradley put into the statutes to command an easily readable and understandable description. Again, I think that's a fair comment or a bit of feedback to the agency that I received this notice, I'm enrolled on your list, and I can't make heads or tails of this. You need to write in a clearer and more understandable way. I will tell you my own personal commitment. I've set as a professional goal for myself when I'm writing reports, not only the rulemaking reports, but generally, is to run them through an analysis called a Flesch-Kincaid analysis, which is a readability index. And I'm aiming for, my goal is to try and get my reports and opinions to read at an 11th grade level. Okay, so I'm aiming at St. Louis Park High School graduates or seniors when I'm writing my report. And if my numbers, you know, it's part of the program in the word processing software that I use, that if my numbers are way high and I'm speaking as if I'm talking to my fellow law lords, I know that opinion is not where it should be, and I need to go back and look at that writing, because I want these materials to be accessible to a wider audience and approachable to the group. And so I think that's what the legislature had in mind. It's certainly what we're trying to do. I will tell you that sometimes lawyers get into bad habits when they're writing, and I include myself in that group. Ma'am.
Hi, excuse me, I was just wondering if you could put it in context, how unique or unusual this is as far as how many states have this type of administrative law. And I guess my impression is that Minnesota is often cited as a model for a lot of things, but I just wondered what your opinion is as far as this contributing to it.
My sense that it's on the spectrum, when I go around and there's a group that meets of the 26 states that are closest to Minnesota's style, both in the contested cases, you know, in the licensing context when we have trials and those kinds of things, and also the work that we do in rulemaking. There's a group of 26 states that meet, that Minnesota is at one end of the spectrum, not only in its early innovations, but its helpful innovations as far as transparency and openness. So I think that amongst the states of the Union, Minnesota has a more complicated process than many, but it's also much more open and transparent and accessible than many. I know that when the Uniform Law Commission was looking at a general set of procedures to propose in its Model Act for administrative procedures that states could choose in selecting, I'm told by one of the Uniform Law Commissioners that whenever they had a tough question, they picked up Chapter 14 in our procedures and see how we did it here in Minnesota. So I think that we are, in fact, a guide. I think that we're probably more procedure-rich. It's more complicated and expensive than many other states. At many sense, it may well be a Cadillac as far as processes, but in the same way that Cadillac might have comfortable features for ordinary citizens, or safety, a good safety record in crashes, to avoid a procedural or legal crash, maybe those features are worth it. You know, that we have procedural airbags, as it were, built into our system that not every state has. I think it also follows, if I could just comment briefly, this is a cultural ethic that is in the legislature as well. that I think our legislative procedures, if you ask Representative Thompson or Representative Leppick, also suggests not only that we rely upon the wisdom of the group, but that individual legislators have much wider freedom, that there is a suspicion of the tight group at the top, and that we have an openness in our legislative procedures, our lawmaking procedures at the Capitol in ways that would be astonishing to legislators from New York or from California. My golly, what one member could do if so inclined to route the discussion in ways that I found, maybe because I like the procedure, when I was a member, I found very helpful. I mean, Representative Lipman is sometimes irritating, but worth the price, because we knew we had confidence in the results, that if there really was a problem that impacted a small group in particular, that group could make itself heard and known and understood and focused upon in ways that, like I say, maybe at the time seemed expensive or costly, but I think in the long run really, really served us well. And so I think in the same kind of culture that we have at the legislature, I think has infused itself in the delegations that the legislature makes to the agencies. We don't necessarily trust the in-group, to make all of these decisions. We're going to have a wider open swath that is transparent to at least have people have their due. Please.
There have been hearings about the copper mining in the north, and there is to be one soon in St. Paul. Does what you are talking about apply to that hearing, and if so, how, and what happens after?
It's my understanding that is in front of the Public Utilities Commission, and if the Public Utilities Commission were to develop rules not only about that particular case, but again, our definition being one of general applicability about mining in general or energy development in general, they would have a proceeding like this. What will happen in that particular case might well be a contested case if the PUC sends it over to our office and says, Judge Lipman, you or someone else in your office, we'd like to have a trial about the specifics of that particular case, because that's not one of general applicability, even though it's of future effect. So to the extent that it would, that the decision in that might not necessarily apply to other mining companies or other energy technologies, it wouldn't be a rule, but there's a parallel process for decision making in individual cases many times that goes before our office. Is that helpful?
Does it follow many of the same procedures in terms of support for their arguments and providing facts and things like that?
There certainly will, because Chapter 14 would go to, and the question is there a similar process for agency decision-making in a particular case as opposed to something that would be generally applicable across an entire industry? And the same kinds of features would be involved in restricting or focusing the PUC's decision-making. There are other parts of Chapter 14 and other parts of our rules, because they have to do with a specific case, particularly if they send that mining case to our office to conduct a trial and to develop a report on the wisdom of that particular decision. But so it's not exactly what I'm talking about here, because these are for general rules beyond a specific case. But even though they're not exact, they tend to rhyme. Okay, and so that they're similar, they will have a similar feel, they'll have a similar transparency, they'll have a similar set of public access points. And there will be public hearings, if they're likely, on the impact of that decision, and a chance to appear and to make a record. And so many of the things that we've talked about here will appear in the context of a specific case.
But it doesn't have the legal examination that your office would apply.
It will have a recommendation from an independent, if they refer it for a contested case. Mm-hmm. So let us say that that the mining company would like a certificate of need for a particular facility, and the Public Utilities Commission says, well, there's some legal questions that we'd like explored. They will many times refer that case to our office, have an administrative law judge preside, conduct public hearings, develop a record, develop a recommendation, and send it back and say, this is what I think you should do. And so while it's not exactly the same standards because it's only in one case as opposed to a general rule, many of the features will seem very similar, and you'll get the best thinking of an administrative law judge.
So even though the paper is saying that this will have future effect on the whole mining industry, that necessarily doesn't apply in this case?
Correct, in the sense that the PUC isn't making the choices of those future impacts. Does that make sense?
Yes, thank you.
Within the rulemaking's big three,
Yes.
if one agency has been assigned to make a rule and another agency says, oh, you're stepping on our toes, is that where you come in to decide that we're going to have interagency cooperation instead of interagency squabbles?
Yeah, I think that and the question is, if one particular agency is treading on the authority that is properly delegated to another agency, I'm sure we're going to get public comment on that question. Many times we have, sister agencies will submit comments in rulemakings of other agencies, and if they were either impacting the delegations that were made to that second agency, or the first agency didn't have authority at all, those are comments that we really do need to hear. So if this is properly a subject that is in some other agency or under some other process, really very helpful to know, because we don't want people to be coloring outside of their delegations.
Okay, so that's part of your job?
It is part of my job, and so we love a comment like that. Because again, it goes, as you say, the big three. Authority is number one. If the agency is not authorized to undertake this action, everything else stops. They could have the best procedure, they could have the smartest rule. If the legislature didn't say you can do this, everything else downstream is nothing. They have no power to act. Please.
I have a three-part question related to the statement of need and reasonableness.
Okay.
First, when it's written, to whom is it directed? To the legislature, or to the administrative law judge, or to the general citizenry? And second,
Well, can I just stop there? And so just so that I don't miss the three questions. So to whom is the statement of need and reasonableness addressed? It is part of the rulemaking file. I would suggest that it's addressed to the public. The part of Chapter 14 requires that they send it to key legislators, usually the ones on the Oversight Committee for Policy. Okay, the people who gave them the delegation, both the majority members and the minority members. They also require them to send it to the legislative reference library so that it's generally available to the public, and to their lists, both the ones that they've thought of and the ones of people who have enrolled. And so it is something that we want to get it doesn't have a particular addressee, but we want to get as far and as wide as possible, and I would get a copy as part of my review. The second part?
thank you. The second part is also, on whose behalf is it written? Is it a statement of why the rule is necessary and reasonable for the agency to have the rule, or why it's necessary for the public to have the rule and why it's reasonable for it to be imposed upon the public?
The question is, in what voice is the statement of need and reasonableness? Is it from the vantage point of the agency or the vantage point of the public? I think, in all candor, it is the agency's judgment of why this is in the public interest. And so it comes from a particular point of view. One assumes that this is the agency's view of the world. They would say that, as shown in their document, their view is consonant with the public interest. We circulate it widely because we don't assume that to be true.
Thank you. And the third part of the question is one you've already partially answered. Where would the statement of need and reasonableness be found if I wanted to look at it?
Sure. In the notices, in particular, they give you contact information about where you can receive a copy if they don't, in fact, send one with the notice. Frequently, it's on an agency website. They'll give you a URL link to the document, because many times it's several pages, frequently, and not unheard of, somewhere between 20 and 80. There's a good bit of proof that the agency is mustering, because it wants to have an affirmative presentation of facts on each part of the rule. And also there's all of those, the 8-factor tests that that I originally described. They go through piece by piece and make a demonstration. Why? Because we're not accepting the agency's word for it. They have to prove it up. And so in the same way that I speak to my 11-year-old, they have to show their work, and they're making that usually, as a matter of course, available on the website. They certainly have to do as a minimum, as a statutory minimum, make it available in the legislative reference library. And the notices will give you a contact person if they haven't done either. Well, that would be a problem if they hadn't done the second one. But if they haven't posted on their website, where you can get a copy and they'll send it to you for free.
Thank you.
Great. We'll take this last one and then it'll be on to the panel. Please, ma'am.
Yes, I was wondering, since I'm not an attorney, I'm not in the legal world.
Yes.
I have a question about specifics, and that's, could you give us an idea of something, a law that was recently passed, and tell us exactly how that moved through something, not extremely complicated, but something that moved through your office, and how a topic in particular, and maybe the citizen hearings and that type of thing, just to make this a little bit more clearer to my mind as how this actually works?
Sure. So, and I hope folks won't keep me closely to the dates. The question is, can you give a description of the overall process? And so I'm recalling one from last summer, a fairly high-profile set of rules that I was involved with. It was a delegation to the Department of Health for the immunization schedules for children in the public schools. Okay, so in order to send your child to the public schools, you ordinarily, as a matter of course, you furnish your immunization records for the child, or you sign a statement saying that you conscientiously object to having your child immunized, but one of those forms needs to be submitted in order for the child to attend public school. When those immunization rules were first developed, I believe in the 1990s, the legislature, in a surprising, but they felt fully informed view at the time, actually went through and set out, it will be this schedule for pertussis, you have to have them in this intervals, and it will be joined with these other set of vaccines at this schedules at this time for these ages, and literally developed and put it into the statute a schedule for vaccines. Interestingly enough, and this is probably makes the example a little bit unique, but the legislature says if the medical science improves through rulemaking, we're going to allow the agency to update the schedule, but they have to do it in a certain way. They have to consult with folks from the CDC and other folks that the legislature, in their judgment, thought were expert, and you have to use their best practices, but will allow you to update this schedule for vaccines. And the Commissioner of Health, on or about the autumn of 2012, thought that it had been some time since the schedule had last been updated, and wanted to have a series of new vaccines and an earlier schedule. They were going to expand the schedule of things that were going to occur. For many people in the community, this was a profoundly controversial and indeed irrational idea, because in their view, not only are the current regime of immunization linked to serious injuries and health effects, but an expanded range of immunizations would be even worse. Okay, so we had a public hearing in June of last year, of 2013, and there was considerable public comment, bankers' boxes full of public comment, and very informed, very thoughtful, literally from people who were in the room and from all across the country, and indeed across the globe. I think we had some international comment on the wisdom of that particular rule, and there was a very searching inquiry about each of the agency's choices as to immunization. I wrote a report suggesting that again, as I suggested here, it might not be the immunization schedule that I would pick, but it was not manifestly irrational. There was a need for a schedule generally, this one in particular, and that among the choices that the agency had to it, the one that they selected was reasonable. Okay, so I sustain that, and there was a detailed assessment of each of these features in a report that's probably 50 pages and available on our website. But that shows from a fairly long-standing delegation to a detailed updating and technical analysis, lots and lots of public comment, articles in the newspaper. We had 3 television cameras at the hearing. I mean, there was considerable public interest in this topic, and we didn't take anything for granted in ways that, in my judgment, I think were a success overall for the process, because there literally was an international review of each of these decisions. Reasonable people can disagree as to the wisdom of the ultimate result, but it certainly was transparent and informed. I hope that's helpful.
Yes, it was. Thank you very much.
Thank you so much. I'm very grateful.
Thank you, Judge Lipman, for spending this really cold, slippery Saturday with us. We really appreciate your knowledge and expertise in rulemaking, and hope that everybody here now is a little more familiar with that process, and hopefully be a little more inclined to get involved in it if you're not already. I will tell you, when I first started out trying to learn more about rulemaking, I went to the House research documents, just because they're very user-friendly, kind of a broad overview. So I would start there before you dive right in to start reading the statutes and the law, because that will be overwhelming for you. But the House research has those documents that Judge Lipman listed there that I think are a really good starting point to understand the process. So, wanted to move on to just a really informal panel. Lynn and I have, I think, varying degrees of experience around rulemaking. We wanted to share a little bit of that experience with you. I will go ahead and just start since I've got the mic, if that's okay. My background is that, I've been advocating for children with disabilities for the past 9-10 years. So I started at Pacer Center as their public policy director, and part of my role there was to advocate for children with disabilities, and part of that was to prepare parents for these hearings and help them understand the process, help walk them through that statement of reasonableness and need, the SONAR that he talked about, and help them answer any questions. So I was kind of the intermediate person. Someone asked, how am I supposed to know when I get this SONAR thing, if, what it means, if it's in very technical language. Well, for some particular groups in this situation, for parents of children with disabilities, you had me as the middleman who helped them interpret what that SONAR was saying. And if they had questions and I wasn't clear on what those answers were, I went and got those answers for them. So I actually worked with parents to prepare them for the hearings, help them write their comments, and those types of things. So what I did yesterday, because I do this and I don't ever really think about the process of how I do it, I did prepare a little handout that I'll hand out to you guys right now and kind of walk through some of these points. This is going to be from what I'm going to call a grassroots organizing perspective. This is how I help people participate in the process, and when we walk through the process, how to prepare their comments. So these are just really just some helpful tips if you want to prepare comments and participate in the process. Some of the thinking, at least, that goes through my head when I'm working with parents of children with disabilities. So I'm going to walk down here a second and just hand these out. We can help you. Okay. And like I said, this is clearly, this is what goes on in my head when I'm preparing for these. So you may have, I know league members and other members of the public may have a process they go through. This is just my thinking, so it's not the only thinking. Okay, I'm going to go ahead and start, because of course, as I was looking through this, I saw something on there that I forgot to put on there, which is always what happens to me when I do this type of thing. Judge Lipman talked about getting your name on a list so you get those sonar reports. That's really the first thing you need to do. You need to get on that list, so, and you can do that through the agencies. So when something comes out around rulemaking, you get that sonar report. That is going to be the first thing you are going to read through and see if you have any questions, get your questions answered. That becomes the basis for just a large part of what you're going to be doing around your comments. So be sure to get on the list for your topic area of interest for that sonar report if it's coming out. So you might want to add that to the top of the list, because I think that's the first thing you need to do is actually, have access to that sonar report. The second thing, and this is going to be pretty obvious, is you have to get together with like-minded citizens possibly and try to, I guess what I try to do is form a strategy for a particular group that might be affected by a rule. So if there's other groups or just other people in your neighborhood who, are supportive of some of the things you're thinking, it's a good idea to try to get together with them and kind of band together, because what you're going to do is write your comments together as a group. And there's a very strategic way I go through the process we'll talk about here as I go down the list of how I go about that. But the more people you can get engaged in the process and help them understand it's not that complicated and they really should go, it's really important, the better. So find those like-minded people if you can. Preparing your comments, and this is probably where I spend most of my time with people. You obviously have two ways of going at this. You can do written or you can do testimony. I do both. I will go the day of the hearing. I will give a very brief testimony, 3 to 5 minutes. I hit the high points. And then I have the written comments that are longer. Those I submit after the hearing. So I do both. Some people will only do the written comments and maybe not show up for the hearing. I actually do both of those things. So I see, does somebody down there have a question? Okay, well, I'll just keep moving on, then we can take questions maybe at the podium. So you have the two testimonies. You have your written and you have your actual testimony that's shorter. Basically, the written comments are good for elaborating on things. So if you have like a lot of extensive facts you want to pass along that's not easily kind of, in like a hearing, actually going through all these factoids, that's where in the written comments it becomes really good. I mean, I've seen people do written comments up to 5, 8, 9 pages, a lot. But you need to be concise, you need to have your facts, be focused about it, and make sure you're addressing the points in the sonar that the Judge Lipman talked about. I would not pick every point there is in the sonar. Pick your top 3, maybe 2, and focus in on those. Put those at the top of your written comments. If you want to make comments about the others as kind of a minor thing, do that toward the bottom. But I really try to keep it focused to 2 to 3 top things that I really am adamant about or think are important. And the same way in your testimony. You don't want to go all over the place. You don't have time to do that. And anybody who's ever gone through a legislative testimony or hearing, it's the same thing. You really need to be very focused. If you have personal experience around a particular thing, obviously you want to include that. But once again, keep it brief, keep it very focused. I've had a lot of people who have personal experiences and they want to tell everything from the beginning to the end. Well, you don't really want to do that. You want to just focus on how it relates to that particular point. So, what I tell parents, and I typically read their comments, if you don't have a person like me, have a friend or a neighbor or another league member read your comments, and just give their impressions of what you're saying. Did they get it? Are they understanding the point you're trying to make? Because sometimes just having another person read your stuff is really useful and very valuable. So, if you have a friend who's willing to read that, have them read it. And that way you've got a second pair of eyes going through it. Other things, I tend to look at the comments, and I have a somewhat strategic way of structuring comments. I try to get all my supporting points, either why oppose or I'm for something. I get all those out on the table. I pick a couple top one or two of those. Then what I will do is typically if we have a group that's going to go and they have comments, they'll have maybe one or two of those comments kind of interwoven in all their testimonies. And then there'll be one that I'll throw in that is very unique to that person. And the reason I do that is because at these hearings, what I typically see is at some point the judge is going to say, everybody said the same thing you've got. And he's going to say, well, do you have anything additional? We've heard this. So at least then you have that point. You can always say, I agree with these other points, but you can kind of elaborate on the one that maybe no one's, already said. So I throw that in there just so you're not, sometimes I think people think saying the same thing over and over again is very supportive. It can be, but at these hearings, I think you need to be a little more strategic. You can still say, I support those points, but also I'd like to make another point. So, I do structure it that way. I'm always aware, obviously, of what the opposition is saying about the issue. And typically, you're going to have some insight into that anyway, because some of these have gone through the state legislature. So they've already, on the public record, testified, so you know what their particular arguments are going to be. And you need to be thinking about that too, I think, and thinking, do you have facts that, kind of counter what's being said? So I really tend to look at what the other side is saying and try to objectively look at, does that sound right? Are there some facts I can present to the judge and to the process that would be helpful? So, I always like to do that. When I go to the hearings, I will tell you I take about 5 copies. I think there's maybe 4 you maybe need. I take extra copies. The first thing important to do from a practical standpoint is get your name on that testimony list on the front table, like when you get there, as soon as possible, because depending on the topic, that can fill up pretty rapidly. So, and I would kind of think of spending a couple hours there. It's not going to be like something you're probably going to run in and out of. So be prepared to spend part of your day at these hearings, because depending on the topic, you may have lots of people testifying, and it may go for more than one day too. So get up there and get your name on that list like ASAP when you get there, because that's the magic. They'll go down that list. So you have your 5 copies of your testimony that you're going to give. Make sure all your contact information is on there. If you've got the docket number, I even put that on there. So there's just no question, because they will enter all these comments in as an exhibit. They will be put on their website after the hearing. So everything that you submit will be of the public record. So the day of the hearing, I will, our parents would come up, maybe do their testimonies. I would do a testimony for the organization I represent. I do sit through and take notes on who's testifying and what they're saying. So if you've got the time, that's well worth the effort too, just to hear kind of what the other comments that are coming through, because there might be something that you want to respond to in the written comments afterwards, because I do go back if there's something said at the hearing that I feel like needs to be addressed. I will submit additional written comments around that and provide facts. So stay away from, I know a lot of parents, that I've dealt with, they are like, well, I just don't like that. Well, that's not how we have to present this. We need some facts. And you can do that through your personal experiences. We can do that by, just straight facts from reports and data, and we can do both. So I think it's important just to really stick to the facts and not try to let yourself get off on a tangent. I don't think that's going to particularly take you someplace. So I think those are some important tips that I have on here. And I put on here, once you read the House Research description of rulemaking or the publication they've got, there's some interesting things in there. Like the one thing I put, and under Know the Law, did you know that an agency must conduct a public hearing on proposed rules if 25 or more people submit a written request? So maybe an agency is deciding it's not going to go through rulemaking and it doesn't want to do that. Well, this is just another mechanism that is within the law, that if you could get 25 people, and I have seen this done, to actually sign this request, that there will be a hearing, and that provides you more opportunity for public input. So, I guess my kind of closing commentary on rulemaking overall, I will tell you, I came into rulemaking, I went to work for Pacer Center in 2007 as their public policy director, and the first thing I had to do was rulemaking, and I knew absolutely nothing about rulemaking. I had done legislative testimonies and those types of things, but I've never done any type of rulemaking, and I guess my best description of it would be a legislative hearing meets a court of law. I mean, that's what it looks like to me, but it's very similar to, a legislative hearing if you've ever testified there, except you have a judge. So that makes it a little bit different. But in terms of preparing like your comments, it's very, very similar, I think, to a legislative hearing in terms of how you prepare those comments. I think you probably have a lot more opportunity in some ways to provide more input, I think, in the rulemaking process, which is what I like about it more. Sometimes at the legislature, you kind of get a couple, one-shot testimony, and then maybe you can run around and talk to members. But the rulemaking process I do like because it is a very open process. I think we have a great system here in Minnesota. I mean, I only have positive things to say about, my experiences with rulemaking. But I think it's important to go in there well organized. I think anyone going in who doesn't know the process and not sure how to participate, it can be a little overwhelming. And I mean, and I say that only because I've had parents and I've taken them there and we worked through all their comments and they were going to testify. And I swear, they got there and they're like, this is too much for me. They would see people get up there and it really, really scared them. I said, you're fine. You got your written comments, just read from your comments. That's all you've got to do. I did tell them, and I will tell you, that if the judge asks you a question, and this is a golden rule of being at the Capitol, and you cannot answer that question, do not take that as a moment to start making stuff up. That's a really bad idea. You can always tell them, you will get back to them with the answer. You're not sure. Write it up. It will probably be entered in as part of the public comments, which is fine. But don't try to wing it. That's a really bad idea. So, please be aware if they, because sometimes they do ask questions, and I frankly tell them, I don't know. I don't know, but I will get back to you. I will write it up. I will send it to you so it can be part of the public comments. So it's very similar to, being at the Capitol in that respect. You want to make sure your credibility stays there. That's really important. And even as a citizen, I think, it just makes you, everything you say more credible if you don't start making things up and then someone else comes along and counters it with some other facts. So you have the little list here. This is like everything I picked out of my brain yesterday driving around in the car, thinking about how I kind of go about this. So think of, when you do comments, and I don't want to make it scary, but I just want you to have some sense of being organized about how you put it together. You can't just throw everything in a pot like a soup and hope it's all going to work out, because probably there'll be a lot of facts in there, but I think you need to be focused on what are the most important things in that sonar report that you want to address. And then, you're probably going to have to let some things, minor things, go. Maybe you have a few comments. You can maybe include those. I would just include those so briefly. But really stay focused on those 2 or 3 items and just keep hammering through that. And if you can show up for the hearing, sometimes I know that's not easy for people to do, but if you can show up for the hearing, be at the hearing, pay attention, as to what people are saying, and, see if there's anything else from the public, another perspective maybe you hadn't thought about. You may not agree with it, but, there's different perspectives, and you do hear different things at the hearing. And then make sure you submit those written comments within that deadline time, because there is going to be a deadline when you've got to get those in. So do both. I mean, I just do both. So I don't know, I'm going to pass it on to Lynn, and then we can actually do some questions afterwards if you have any further questions. But hopefully this will help a little bit in structuring your thoughts around comments.
I think that's absolutely true on all levels. As many of you know, I'm working with the Action Committee, and our co-chair, Kathy Tomsich, is here today as well. I think Kathy might also have some other comments after the meeting that she can help with. I support environment, and environmental issues very often are split between Minnesota and federal levels. And there is a federal process for rulemaking as well. It is not always as transparent as Minnesota. Polymet, for example, falls in both, which is why there's sometimes some confusion about the mining issues, because there are both Minnesota and federal laws that apply to it. I absolutely agree with Kim. You've got it. When you submit a comment, whether it's online or in person, stick to the facts. You know, you can certainly say things like, if you do this, this will, take 40% of my income away or something. But don't get hysterical about it. Try to factor the emotion out, because that is exactly when people start turning off and your credibility comes into question. It's fair enough to say this is going to be really upsetting, but you don't have to go further than that. Lawmakers, judges are looking for people who can think and certainly can react, but react effectively. So I strongly support, it's great. I think this is the worst thing since the square wheel, probably not a good idea. I do encourage you, if you're not the type of person who feels comfortable doing this on your own, there are lots of nonprofits out there who usually have a connection to some issue that you're concerned about. Many of them will send you a notice saying, this is coming up for public comment. Please make sure you get those in, and here's a suggested text. You can use that text or you can modify it to your own, but they will keep track of this for you if that's not something you want to try on your own. And then you also have an ally and people you can rely on to get information that is relevant to your issue. And whether it is something you support or something you hate, you've got somebody who's got some links to really good information that you can rely on to put into your own comments. As an example, just this last summer, the PUC was looking at a request to shut down Sherco 1 and 2, which are coal-fired electricity plants. And the environmental community, of course, is very much in favor of that, and Excel is not. But the environmental community sent out notices through its various groups to people saying, hey, this is public comment time. There were 11,400 comments that came in. And because of that, and these are not people who went to the hearings, those were packed too. But just from that, just from the advocacy standpoint, they mobilized people to submit those comments online. And that did influence the PUC's discussion and ultimate decision to recommend that Sherco ultimately transform by, I think it was 2020. They have to start getting, either shut them down or get power from a different source, a renewable source. This is the kind of impact you can have. So if you sit there thinking, oh, it isn't going to make any difference if I don't say anything. Well, if you and you and you and you don't do anything, nothing happens. But when 11,000 people individually make that decision, it makes a really big difference. So yes, you do matter. No, you don't have to be the professional. Yes, you can get help. I encourage you, those who have interests in specific areas, find out which groups that are supportive of your view. Talk to them, find out which agencies you should be paying attention to. Both the bills and the rulemaking are mostly online in Minnesota now, and you can get those notices sent to you. You don't have to keep track. You don't have to remember to go back and look and see if there's anything new this week. It will come to you. So just as Kim says, you've got to prepare, be fact-based, be rational, but stay in touch with the groups who support your view, whatever they may be. And when they tell you it's an open comment period, really take advantage of that, because you do make a difference in the long run. Questions, comments? Yeah, please.
Yeah.
When is an administrative law judge's report a recommendation, and when is it binding? Or is it always just a recommendation? And what is the public's recourse if they happen to disagree? Is it strictly through the legislation?
I'm going to call Judge Lipman up here because I kind of feel that as a process question. So I'm going to let him take that one.
So just so that I can repeat, Representative Lepek wanted to know when an administrative law judge's decision is a recommendation and when it is the final decision. So in the rulemaking context, okay, we'll talk about contested cases in a little bit because it's a slightly different process. In the rulemaking context, if I find a legal defect in the big three, they don't have authority, they violated some part of the procedural rules in Chapter 14, or they haven't shown that the particular regulatory choice that they've made is needed or reasonable, that is the decision. They don't have the good housekeeping seal of approval. There is review of that. If I find a defect, it goes to the chief administrative law judge. She will review and either affirm or reverse, and sometimes it happens. An administrative law judge will find a legal defect, and the chief administrative law judge will reverse that determination. And presumably, beyond that, the agency has a number of recourses. Let's say that administrative law judge finds a defect. The chief administrative law judge affirms that decision just for the purposes of our hypothetical. The agency can, in fact, adopt that rule. Okay, the delegation goes to them. It doesn't go to us. But I think the likelihood that they're going to go and get sued is quite high. Okay, here, two judges said that you don't have authority or this is defective in some way. You did it anyways. That is going to be very risky. It doesn't. So that situation does not, in fact, happen. Another possible recourse is that they could take an appeal to the Minnesota Court of Appeals. I think a more likely recourse is that they would go to the legislature and say, they said that this was defective. We would like a change in the delegation or the law to make clear that it is okay. Or another option would be that the agency could revise its rules so as to come in conformity and to fix the defect. And whenever we identify one of the defects in our rule reports, many times, most oftentimes, I do as often as I can, is give a suggestion. Here might be some alternatives where you could address that particular problem. Okay? So in the rulemaking context, while it's subject to further review, at least for the time being, my withholding the good housekeeping seal of approval for a particular rule, and all I do is approval, not approval. It's not a substantive choice about the rule. But if that is withheld because there's a defect, that is the decision until it's reversed by or changed by a higher authority. In the contested case process, where there's a trial as to a specific party or set of parties as to a particular fact pattern, in 90% of the work that ALJs do, it is a recommendation for a commissioner or for a board to make that final decision. Many of the kind of PUC decisions that we've been talking about here today in the energy context, an ALJ will conduct a trial and make a report that is acted on later by the PUC so as to save that five-member body. They're all very bright, but to have them stop from their ordinary business of governing all utilities to conduct a trial in one, sort of time-consuming. Okay, and so they'll hire our office. We'll conduct the trial, develop the record, develop the memo, have all of the pieces with a recommendation, and just like a city council would act on the work of the planning commission or another, the Parks Commission. Similarly, the PUC would operate in starting with the report and recommendation. Chapter 14 also provides that in any particular case that an agency wants, they can delegate final decision-making authority as if I were the commissioner. They can say on a case-by-case basis, they're allowed, this one, Judge Lipman, you take. And there may well be, for political or resource or lots of other reasons, why they would say, you'll make the final decision as if you were the agency, and we'll have that appeal appeal go through the Court of Appeals and the state court process as if it were me deciding, okay? There are a smaller percentage, another 10% of the cases, in the campaign context, in cases involving discrimination, in cases involving special education, where and these are all in statute, the decision of the ALJ is the decision on behalf of the agency. So the legislature sometimes makes, as to whole categories of cases, the decision that, not in a case-by-case, but for these types of cases, the ALJ will have the final decision of the agency, and it will go through the Court of Appeals process. So in different kind of contexts, just as in the same way that we look at the agency's authority to promulgate a rule, the administrative law judge will have different kinds of authority to render a final decision as an initial matter. But in most cases, having to do with litigants in a trial in a particular set of parties, 90% of the work that we do is recommendations for another person, and about 10% is final decision-making authority. In the rulemaking context, again, it is the first of many final decisions that are subject to later review. Folks sort of clear about that? But now you are experts in administrative law. You know all there is to know. With thanks.
Thank you. Now you can see why I had him handle this question. Do we have any more questions?
I want to thank you for this presentation. I've learned lots and lots of things. However, I missed one important point, and that is why pay attention to the rules at all. Very often, people say, well, a law was passed and it said this. What you don't know and don't investigate is what the rules say as to how it's going to be implemented. I'm a legal assistant, and not a lawyer, but a legal assistant, and I love the research. I always looked at the law and the rules, and I think it behooves all of the league members to know that these two things not only go together, but are important to know both of them.
That's a really good point to make, and I'm glad you did. Once a rule does pass, once it gets through the administrative process, it does have force of law. So that's why it's really important to pay attention to these. Yes, the bill gets passed. Yeah, we got the bill passed, for example, in solar energy last year. But there's a whole lot of now how do we implement this thing. Excel now has to come up with a plan to do it. That's going to go through the administrative process. And that will become force of law. So that is why, even if you think, oh, great, and as Kim made the analogy earlier, we got the bill passed, isn't that good enough? It's a great first step, but if there's an agency involved, and there isn't always, but if there is, there will be rulemaking, and that's the next thing you need to participate in as well.
I also want to just thank Mary for that comment, because I almost put a bullet point on this flyer that says, are we done yet? Because, it is exactly that. We get to the state legislature and we work so hard to get laws passed. And I think sometimes we're just so exhausted. We're like, okay, we've got to be done. And I don't think it's really, there's no ending point. I see it as a circular process. You pass the laws, you look to see how they're implemented. There may or may not be a rulemaking piece. But if a law isn't working, the mechanism, you can go back to your policymakers and start there. So I see it as a circular process, not a linear, a beginning and an ending process. It's constant. I hate to say that, but it is constant. Even though you pass laws, sometimes they have unintended consequences. Sometimes they don't work the way they should. Sometimes rules don't work the way they should, but that doesn't mean that we accept them. We have to accept that. As the public, we can be engaged and, change those things to make them better. And I think it is part of our public responsibility to do that. So please, I know rulemaking is one of those things. I wasn't aware of it. I don't think appreciated the impact of it until I got involved and understood just passing the law is not enough here.
Thanks again for the presentations today. I think it's been very helpful and informative. If you were chief wizard of the day and you could change something about this complicated and apparently time-consuming process, all three of you, what one thing or set of things would you do to do things differently?
Well, in my case, I think I would definitely ask that the federal government develop a system that is as open and transparent as ours. Even though I know people feel that Minnesota's, if you didn't know about administrative law, you didn't know it was happening. But among the administrative law systems, it's incredibly open. And I'm not sure how much more you can do to tell people. Normally, when we request, when somebody or the agency is requesting public comment, it's printed in papers, it's announced on websites, it's all over the place, but you have to be aware of those websites and the papers to begin with. I'm not sure what other means we could use, and if you have ideas on that, it would be great to hear about them. Certainly, because the more people you get involved, the better we're going to get at this. I would like to see the feds do the same kind of process. I know that I can go to PUC and sign up to get their notices. Not every agency makes it that simple on their website. I would love to have that be a state standard.
I guess since I've got a 21-year-old now who probably knows more about technology and everything beyond me, and I rely on her, I would actually like to see probably more civic education around rulemaking in schools. I think really somehow getting to our youth and helping them understand, I know they get the education about how a bill becomes a law because they're always at the Capitol all the time. I don't know if they understand these other mechanisms that the public can use, and perhaps Judge Lipman knows of, education like that, but I think it's really important. If I could change anything, it would be making sure that our youth are aware of the ways they can engage in public in terms of their laws and their society. So, and I think rulemaking is one of those invisible things that people don't know about. So I think educating youth on all those different ways they can engage is really important. So do you have anything else to add? What you would change?
Well, and I'll just speak in my personal capacity here. I'm not necessarily for the office if I was granted the wand. One of the things that I think is really a really very helpful thing, I alluded to it a little bit in my remarks, the reviser of statutes, Michelle Timmons, has done an unbelievable set of work in developing that MARS system, that Minnesota Administrative Rules status system. She's basically taken carryover funds. She scrimped and saved and didn't use too many pencils or legal pads and turned off the lights in the coffee pots. And then there was a little bit left over in the kitty, and she has dedicated that money that was left over to a genuinely important public purpose, which is through sort of baling wire and string and dedicated help from some very clever people, developed a system where there can be public access 24/7 from wherever there's an internet connection to these materials. I would like to see, if I had a magic wand, all of the rulemaking documents that are on that filed with the MARS system, and I think this is sort of, we're developing a platform, but it isn't quite there yet, and so that all of the rulemaking record would be available online from that system. Right now, there are key documents. Again, they've done just an unbelievable job with the resources that they have. But I think our rulemaking statutes, while ahead of the nation, are still hidebound in a sort of 1980s, 1990s sort of way of we move the file from this agency to OAH and then to the Secretary of State and then to the Governor's office and then to the History Center. The reviser's in there, and as if you were taking a red rope file or a manila folder and literally moving it across all of these particular agencies. Much, much better if all of the filings as an initial matter were made online, were transparent and available to everyone in real time, could share documents, could add to the documents, and that you could see the rulemaking record in one place. All of that, I think, would be greatly advanced. The legislature, while generous, has not yet taken that step. I think that would be a helpful bit of engineering, and we're almost there.
I think the only thing we have left here is really just to highlight the resources. You have two handouts here. that you can look at. You know, if you have any particular, I'm going to say general questions, I'll offer myself up as a resource, but I would read those House research documents first because they provide just a good overview before you start diving into reading the law. Eventually, you're going to want to read the law because you'll find the things like the 25 signatures and all those handy other little things to know on how you can influence the process if it looks like they're not going to have a hearing or, you know, or a situation in that nature. So I don't know if anybody has any questions about the resources. They are listed. If you have any questions, you can get in touch with Lynn or I, and, you know, we can get in touch with Judge Lipman as well to get those questions answered. So I think you've got the closing comments.
We would like to thank you for being here today. We particularly want to thank the City of St. Louis Park for allowing us to use their facility. Those of you who may have an interest in either joining the league if you aren't a member, or if you have, or know folks who should be, and you probably do know who should be, please remember to sign up at the tables in the back. Thank you for coming, and enjoy your winter.
Thank you.